Now, if you think about the interrelationship between DPSP and fundamental right, it has actually gone through various stages, right? Now, what stages it has gone through? See, if you think about it, the first stage was that DPSP has nothing to do with fundamental right. Each and every fundamental right is a code in itself. The provision of fundamental right is nothing to do with DPSP at all. So whatever the question arises with regard to fundamental right must be settled by fundamental right itself. You cannot take into account provision of DPSP. Completely a code in itself. The initial construction, and that was also sometimes referred as the textual construction. It means the code will only look at the text, not the underlying feeling of that text. So there's two, interpretational doctrine in our constitution and everywhere, right? The one is the textual interpretation. You read only the text, nothing else. And second is the functional interpretation, meaning you also talk about the feelings or the historical underpinning of that particular text. Like for an example, if you, today itself the article that I sent you with regard to Article 17, so if you only look at the textual interpretation, you will only feel like it only covers untouchability. But if you look at its functional interpretation, so it will cover every action which discriminates, right? So textual interpretation will only remark that Article 17 only covers untouchability, nothing else. But if you look at the functional interpretation, what it will say? It covers everything which discriminate, including untouchability. Okay? So the first approach of the court was textual in nature. Now the reason for this approach was that most of them were British trained jurists, and in Britain, as the parliament is sovereign, they stick to the text. They don't try to become hero or decide political question. Why? Parliament is already there for that. Okay? But in our constitution, that was not the case in the beginning. We thought, let us stick to the text, right? Then the second stage came. In fact, very famously, if you think about it, that case related to habeas corpus, case very famously referred as, yes. That case, Justice Chandrachud very nicely, talks about Article 14 has nothing to do with any other article of the Constitution. And the lawyers started to argue that Article 14 has to do with 19 and 21. Chandrachud rejected the argument that no, 14 is a code in itself, not talk about any other article, just talk about 14. So that was the initial approach, right? Then came the second stage. And second stage, the court started to say that no, there is some link, right? There is some link between articles, but they said that that article link is only limited to different article itself within the fundamental right. Okay, 14 has to do with 19, and 19 has to do with 21. Okay, but it do not have to do anything with other chapter of the Constitution. Right? So, little bit we started to see it as a functional approach that okay, there is interrelationship, but that interrelationship is limited to the article itself, not with other part. And then came the explosive approach, sort of the most widest approach, and we started to say that no, fundamental right have linked with every provision of the Constitution, including DPSP. Understood that particular point? Now, between them, this approach was actually superimposed on the Supreme Court by the legislature by providing Article 31A and B, which said that legislative enactments cannot be held invalid only on the ground it violates fundamental right if it provides that this law have been made for the purpose of enforcing DPSP. Right? So उन्होंने कहा कि if there is a DPSP and there is a law which says that I am enforcing this DPSP, so even though it violates fundamental right, that's all right. Right? So it means the legislature is forcing Supreme Court that you make a connection between DPSP and fundamental right. Now the legislature made the connection, and what the connection said, that DPSP is superior than fundamental right. Obviously that was held invalid in Minerva Mills, right? And the court held that no, DPSP is not superior, but still there is a relation, and the relationship is what? The relationship is constructive in nature, meaning that DPSP articles should be used for the purpose of interpretation of fundamental right, nothing else. Understood that particular point, right? So it means if you think about the interrelationship has traveled a long distance from a strict different part to there is a relationship between different articles of fundamental right, okay? And in that also there are sub part also, like initially the court said that see Article 14 has relationship with 15 and 16, but not with the Article 19 and 20, which is provided under different headings. Right? Then the court came and that said that no, this heading is not important. Every article have interrelationship with each other. In fact, the article that I sent you today, Article 17, here Justice Chandrachud, gives you the relationship between 17, 25, 26 and 28. Have you read the PDF that I sent you in the Telegram group? नहीं देखा आपने, देखा ही नहीं. देखिए टेलीग्राम पे जो भी मैं मैसेज भेजता हूँ वो इम्पोर्टेंट होता है. मैं जय माता दी और गुड मॉर्निंग के मैसेज नहीं भेजता हूँ, ठीक है? तो एक एक टेलीग्राम के मैसेज को पढ़िए, ठीक है? साथ में मैं कमेंट भी लिख के भेजता हूँ कि व्हाट इज दैट, ओके? दैट इज वेरी रेलिवेंट, ठीक है? उसमें फर्जी के मैसेज बिल्कुल नहीं आते, ठीक है ना? तो उसको पढ़िए, एक एक लाइन को पढ़िए. देखिए ऐसे ये वाले नहीं, वो मेन वाले ग्रुप में. ये भी मैंने कॉन्स्टिट्यूशनल टेंशंस का भेजा था आप लोगों को. हैव यू सीन? मैंने अंडरलाइन भी किया था कि दीज आर द टेंशंस दैट यू कैन राइट, ओके? और मेन वाले ग्रुप में भी मैंने जो सबके लिए ओपन है उस वाले ग्रुप में ही मैंने आज भेजा है, ठीक है? उसमें भी आप देखिएगा देयर इज ए प्रोविजन फॉर दिस, यस, देयर इज ए प्रोविजन विद रिगार्ड टू आर्टिकल 70, ओके? क्या चलिए ये बात समझ में आ गई कि हाउ दिस रिलेशनशिप हैव बीन गवर्न, ओके? लिखिए इस बात को, राइट इट डाउन.